name is Ravnsborg. I practice law in Washington, D.C. and Connecticut, and I'm here assisting Mike Butler in the defense of the Attorney General. I also teach impeachment and political investigations law at Tulane Law School, and have represented over the past 20 years 5 governor's offices in connection with formal impeachment proceedings. So what I'd like to start by doing is spending some time talking about why we're all here today. And that is not a criminal case, it's not a civil case, it's not a traffic matter. This is an impeachment and removal proceeding. And make no mistake, members of the Senate, what you are here for is incredibly rare in the American experience. As you know, no elected official in South Dakota has been removed through the impeachment process in the entire history of this state. You may also know that not a single federal executive branch official in the entire history of the United States has been removed through the impeachment process. In the entire history of our country, in all of the states, in fact, only 8 governors have been removed. All the states, the entire history. In the modern era, which I define as since 1929, only two governors in all of the states have been removed through the impeachment process. And only 5 other state officials have been removed through the impeachment and removal process. You think about how many governors, how many state officials have been elected. This is incredibly rare, what's being contemplated here. I have found no record of any attorney general, certainly in the modern era, any place in the country being impeached and removed. And I have found no situation in the modern era, certainly, where an official, an elected official, has been removed for conduct not integral to the performance of their office. And so let's think about some examples. What gets an elected official, somebody who voters go to the polls and elect for a term of office, what gets somebody removed by a legislative body? I'll give you just a few examples, and there aren't very many throughout history. For example, 1941, the Massachusetts Governor's Council, Daniel Coakley, was removed for selling pardons. That's the kind of thing that gets an elected official chosen by the voters removed from office. In 1988, Arizona Governor Evan Meacham was removed from office for loaning $80,000 of state money to a business that he and his wife owned. That's the kind of thing that gets an official removed. In 1994, Missouri Secretary of State Judith Moriarty was removed for using her office to help her son in an election. In 2005, the University of Nebraska Regent David Hergert was removed for misconduct in his campaign for office. In 2009, Illinois Governor Rod Blagojevich was removed for trying to sell a United States Senate seat. That's the kind of thing that gets you removed from office. And notably in that case, the Senate in that case was unanimous. It was not a close call. The Senate acted unanimously because it is quite a thing to reverse the will of the voters. And the Senate in Illinois acted unanimously in doing that. Here's a situation that didn't warrant impeachment and removal, and that was a formal impeachment investigation of the governor of South Carolina, Mark Sanford. In that situation, there was a formal process because the governor of that state left the state, didn't tell anybody where he was going, ditched his security detail to carry on an affair in South Carolina. I represented the governor's office in that case, and the legislature made the decision that that conduct was not good. It was not acceptable. It was not appropriate. But it did not rise to the level of impeachment, and Governor Sanford was not removed from office. He was censured but not removed. And here's why. Here's why it makes sense that these things are so rare, that the standard is so high. And that's because of the Constitution. The Constitution of South Dakota is much like the Constitution of the other states, is much like the Constitution of the federal government. And there are three principles in play here. It's not just the impeachment clause. We're going to talk about that in a second. We have separation of powers, separation and balance of powers principles. We have the principles in the Constitution regarding elections in terms of office, and we have the constitutional provisions related to impeachment. So let's start with separation of powers. Under the separation and balance of powers in the Constitution, it's one of the geniuses of the American constitutions, we have co-equal branches of government. The executive branch is co-equal to the legislative branch. The executive branch doesn't dominate the legislative branch. The legislative branch doesn't dominate the executive branch. And so, for example, this is not a parliamentary system of government. This is not a system of government. We see it sometimes in parliamentary systems like England, where the legislative branch holds a vote of no confidence in the prime minister. We don't have that here. And that's because the legislative branch and the executive branch are co-equal. The legislative branch doesn't oversee in that way the executive branch. And the framers of the U.S. Constitution were actually very concerned in structuring the federal Constitution about creating a system where the legislative branch would have dominance over the executive branch. And keep in mind, what you do over the next couple of days could have implications for government in South Dakota, for the history of South Dakota, for the interplay between the branches of government in South Dakota. And so I'd ask you to please keep in mind those separation of powers principles. The second notion, constitutional notion I mentioned, was elections. Again, genius of the American system. In South Dakota, as you know, you elect your attorney general. Voters go to the polls every 4 years. It's built into the Constitution. Voters go to the polls every 4 years and they vote. And they voted, in this case, for this attorney general. And also in your Constitution, there's a fixed term of office. It's in the Constitution. It's 4 years. The legislature doesn't have the ability to cut that term short. It's in the Constitution. It's a 4-year term. And the reason for that, and your framers, just like the federal framers, took a lot of these things into account, is that you trust the voters to make decisions. The voters get to choose their attorney general, just like they get to choose their governor. And every 4 years, a short period of time in history, every 4 years, the voters get to go back and choose their attorney general, choose their governor again. And if they don't think the attorney general is doing a good job, if they think there's a reason why the attorney general shouldn't continue to serve, then they don't reelect the attorney general. Or if the attorney general thinks that he can't get reelected, then he doesn't run. But the system trusts the voters. It trusts the political process to make these decisions. It doesn't put the legislature in a position of making these decisions. So let's look closely at the third provision of the Constitution that I mentioned, and that is the impeachment and removal provision. That provides that the governor and other state and judicial officers shall be liable to impeachment for drunkenness, crimes, corrupt conduct, or malfeasance or misdemeanor in office. In office. Now, the committee of the House that investigated this and the Nebraska Supreme Court, in the only case I could find of an impeachment proceeding involving an attorney general, noted that an act or omission for which an attorney general may be impeached and removed from office must relate to the duties of that office. Now, as the House committee noted, there is some linguistic trick you can do to read the in-office part only with respect to malfeasance or misdemeanor. But number one, I'll note that the Attorney General here is accused of malfeasance, so unquestionably the in-office part applies there. But I'd submit it also applies to the rest of the article. I don't think it could fairly be argued that drunkenness by any executive branch or judicial branch official would warrant removal from office, or that any crime, you think of the vastness of the criminal code, that any crime at all would warrant removal of a governor or an attorney general or a member of the judicial branch from office. No, it's got to relate to the office and be integral to that office. Now, the Attorney General is accused of malfeasance. Again, in the House report on this matter, it cited a South Dakota Supreme Court case that defined malfeasance as reference to evil conduct or illegal deed, the doing of which one ought not to do in the performance of an act by an officer in his official capacity that is wholly illegal and wrongful. So as you consider malfeasance, consider whether it was integral to the Attorney General's office and whether it rose to that high a standard. So members of the Senate, we heard a lot this morning about a very tragic situation. But this is, as I noted, a very rare and solemn and unusual and weighty impeachment and removal proceeding. This is not, as I mentioned before, a vote of no confidence. This isn't a civil case. This isn't a criminal case. This certainly is not a bar case. The objective here, the issue here, it's not to punish. It's not to provide restitution. It's not to reprimand. It's not a recall effort. It's not to make a statement. It's not an employment action. It's not a censure provision. This is undoing the will of the voters. Make no mistake, that's what you're considering doing. And here's, in the case of Nixon, the House Judiciary Committee conducted an investigation and produced a report, the Rodino Report. Here's how that report put it. Impeachment is a constitutional remedy addressed to serious offenses against the system of government. Impeachment is directed to address constitutional wrongs that subvert the structure of government or undermine the integrity of office and even the Constitution itself. The committee went on, the crucial factor is not the intrinsic quality of behavior, but the significance of its effect on our constitutional system or of the functioning of government. That's the measure, members of the Senate. Federalist 65 looked at it. Federalist 65 said impeachment and removal is reserved for those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of a public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself. That's the standard. That's the standard. And the prosecutor's burden of proof reflects that standard. It is very high. The prosecutor has the burden of proving this to you by clear, satisfactory, and convincing evidence. A very high standard, which is why I think you saw in the case of the governor of Illinois a unanimous conviction. This has to be something that the prosecution proves by clear, satisfactory, and convincing evidence, and that constitutional standard that I discussed was met. In this situation, it doesn't exist. But I'd ask, as you consider it, because it's your decision that matters, you weigh those constitutional standards. You weigh the burden of proof. Thank you.
Mr. Butler.
I want to begin by focusing on House Resolution 7002 that sets forth the two articles of impeachment. And I've asked that those be put on the screen, and I'll first focus on Article 1. Article 1, the first that you must consider, the first that you must find that the government's lawyers have established by a standard of proof that we believe is appropriate, clear and convincing evidence. It states Attorney General Jason Ravnsborg committed crimes causing the death of Joseph Beaver. It then breaks it down into three subparts, focusing principally on the driving outside of his lane of travel. I want to stop now there. There has been no finding that Mr. Ravnsborg was criminally culpable for the death of Mr. Beaver. This happened on September 12th of 2020. Bureau of Criminal Investigation out of North Dakota was brought in. South Dakota Highway Patrol was brought in. I believe as Special Prosecutor Mike Moore stated, as did Emily Sovell, the most investigated accident in their lifetime in the state of South Dakota. In the end, after the investigation, the charging decisions were made. A lane violation and distracted driving using your phone. The special committee rejected this as a basis for a finding that he should be impeached. Commenting on the lane change, this is a common violation that occurs each and every day in the state of South Dakota. It is insufficient for removal of a constitutional officer. And again, I go back. There is no finding here of criminal culpability in the death of Jason Beaver. None. I respectfully submit to this body that Article 1 is not complicated. It requires a vote to not sustain the article of impeachment. Article 2, malfeasance, which we know by now requires conduct occurring in office. Attorney General Jason Ravnsborg committed malfeasance by the following wrongful deeds. Following the collision, he identified himself by his official title, made a direct misrepresentation to the dispatch officer, misleading first responders as to the crime he had just committed. If you want to assume for a minute that was done while in office, which my assumption is for the sake of discussion, not because I believe it, I hope that you do listen to the 911 call. Don't accept my interpretation of it. Make your own. He did identify himself as the Attorney General, said that he had struck something, was asked if it was a deer, and he said it could have been. Now, according to the government lawyers, this somehow gained an advantage for him, was a misuse of his power. Folks, he called 911. They dispatched Sheriff Mike Volek, who was there within minutes. He lived nearby the accident. Sheriff Volek arrived at the scene. They both walked up and down the area of the road and ditch. Mr. Volek, when he was interviewed, said, "I would have walked right by where the body was in order for me to see the small light that he did see." Sheriff Volek said, "I did not see a body." I've not heard the allegation that Sheriff Volek is incompetent, was dishonest, or was also engaged in a conspiracy to cover up. I submit that the tragedy that did occur here was traumatic. There's no question about that. The government lawyers would have you judge him now in hindsight, but not for what occurred at the moment. And again, please listen to the audio recording of the 911 call. Listen to his first interview done on the 14th of September. Without legal counsel, he was asked to come in, and he did. Certainly the Attorney General knew of his right to counsel. He waived that right and went and answered questions. In that first meeting, they asked about his cell phones. He turned over his personal phone, gave consent. And on this point, I will say, at every stage of this investigation, the Attorney General consented to everything. Every piece of property, every piece of electronic equipment the government wanted to analyze, he consented. Those are not the actions of a man trying to conceal wrongdoing. On the 30th, let me back up. He kept his work phone. His personal phone was turned over 2 days following the accident. He kept his work phone at that time. Then, on the 15th of September, 3 days following the accident, and I don't know if you can put that up on the screen, but he went to the Department of Public Safety here in Pierre, and he turned over his work phone, gave his consent to search it. That consent did not reveal any misuse of that phone, any attempt to delete or alter any data coming off the phone. Nothing. That same day, but later, the Attorney General goes to the Mickelson building here in Pierre, where his offices are, where DCI is. He did run into Mr. Gromer, who I believe is now retired. He did ask him, about the forensic technology, its capacity to capture in real time what was going on, such as use of his cell phone flashlight, would the timing be accurate, etc. He was seeking information, but he wasn't seeking advantage. His phone was turned over. The devil's in the details, but the details support that Attorney General Ravnsborg at all times cooperated with this investigation, which went on for several months until February of 2021. Appearing before the House Special Committee was Prosecutor Mike Moore, Prosecutor Emily Sobel. And I've included those reports and documents that I submitted to be uploaded because they reveal a very thorough investigation. Many questions asked, many questions answered. Some questions could not be answered, including by investigators. Both prosecutors waited until the investigation was completed, then by their account, following meetings, discussions, etc., considerations of the elements of each offense that could be charged, came up with their decision. Class 2 misdemeanor lane change violation, distracted driving. The cell phone would reveal that it was no longer in use 90 seconds prior to the accident. And so while some may want to talk about it, it was not a factor in the accident. That evening, driving back from Redfield to Pierre, he spoke approximately 25 minutes with his father. He spent 5 minutes looking at headlines from political websites, and the phone was locked and off 90 seconds before the accident. Those are the unrefuted facts of this case. Any effort to twist them otherwise would be improper. When he was asked, was he in the center lane, or was he in the center of his lane of travel when the accident occurred, or in his lane, he said he thought he was. In fact, he strongly said he was. But it turns out he was wrong. The Highway Patrol accident reconstruction investigation that followed establishes that. His vehicle went off on the shoulder of the road. Exactly how far is unclear. Special Prosecutor Moore said there's no question it went off the road, but exactly how far was not clear. But we accept that finding, not here to dispute it. But I respectfully submit, and in my career it has proven to be true, that people can be involved in traumatic or tragic events and have two very different views of what happened, or believe that they did do something that later establishes they didn't. It's not proof they're lying. It's proof they're mistaken. Being mistaken is not impeachable. Being mistaken is human. And although Attorney General Ravnsborg was elected Attorney General, he did not leave the human race and become perfect. He's still not perfect. But what he did here, each and every step along the way, was to provide complete cooperation. He didn't have the answer why he was wrong as to where his vehicle was located, but he was not lying about it. And if you're going to say he knew it and he was lying, don't just say it, prove it. Prove it by clear and convincing evidence. Allegations are easily made, and it is especially true today. They're made anonymously, mean-spiritedly, but when we come here to this chamber, you have to put your name behind it. You have to answer for it. If you know he lied, don't just say it, prove it. During his second interview, Mr. Ravnsborg was asked, would you take a polygraph? Now, in this case, what could you polygraph on? Was it a human being that you hit? Did you see a human being in the ditch? I think it's a pretty clear question. He responded, absolutely. I'll take a polygraph. And he said it more than once. I'll take the polygraph. A polygraph is an investigative tool. It is not admissible to prove guilt, but it is used frequently. Hence, that's why prosecutors, or I should say law enforcement, always have polygraphers on their staffs. But it is used to conduct investigations. If someone is deceiving, it'll indicate so, and they'll be confronted by it. If someone is not, they may be cleared. It's a powerful tool. Mr. Ravnsborg, the Attorney General, when asked, so if we arrange for a polygraph, you'd be willing to take one? Absolutely. I'll go to North Dakota. Hell yes, I'll go. I'm willing. But no polygraph was ever offered. When the polygrapher from North Dakota was here before the special committee, he was asked why. And he opined that, well, I discussed it with some others, and we concluded that even if he's telling the truth, they'd probably show he's lying. I can tell you, I've never heard that before. A qualified polygrapher understands that everybody under investigation believes somebody thinks they might be lying. But it's their skill as a polygrapher that is supposed to be able to discern that and eliminate that from the consideration. An alternate view is, well, what if he passes? Are we better off just not knowing so we can make an accusation that he really can't answer? I say you knew, but I didn't know. I didn't see it. I say you did, but I didn't. And back and forth it goes. A polygraph and its results would have appeared in the investigation. As we go through, or the government goes through its case, establishing on each article its proof, clearly and convincingly, I'm going to ask that you listen carefully and ask how it supports each of the articles, how it establishes that a crime that qualifies as impeachable was committed, and malfeasance in office. In considering that, here is a definition provided by our state Supreme Court on the meaning of clear and convincing evidence, evidence that is so clear, direct, weighty, and convincing as to allow the trier of fact to reach clear conviction of precise facts at issue without hesitancy as to their truth. That is a high standard, as it should be. Now, I do respect that your task here is a weighty one, but I also respectfully submit it's not a difficult one. We shouldn't be here. As the addendum to the report filed by the special committee indicates, undue influence was brought to bear on the prosecutors to charge something more serious. Undue influence was used to persuade members of the House of Representatives by robocalls, by billboards. The special committee asked that it stop. The head of the Department of Public Safety, Mr. Price, was removed from further discussions with those involved in the investigation because of his efforts to unduly influence the outcome. Now, that's wrong. I trust that the line has been drawn, and that will not occur here. We know that the public may not understand exactly what impeachment entails. We understand that. And they have opinions, but they're not fully informed about what must be found specifically in our Constitution, by what standard of proof, and does it apply in each of the articles. If you follow that and you acquit the Attorney General, you can hold your head high because you did the right thing.